Justice Kavanaugh?
You've touched on what's happening on the ground, and that's an important consideration and answer to the question of what's happening. But Idaho is representing, and I just want to get your answer on this, that, as I counted, 9 conditions that have been identified by the government where EMTALA would require that an abortion be available. An abortion is available under Idaho law, and that's in the reply brief. Now, are there other conditions? You've ruled out mental health. Are there other conditions you would identify, or are you just saying that that's not really happening on the ground? I think that's part of your answer, but I just want to get a fuller answer on that.
It certainly isn't happening on the ground. These are the conditions that we're worried about. And I think the problem with my friend's theory that Idaho law would permit it is that you just can't square it with the text of the statute. You know,
what
state
if
of Idaho is.
Keep going.
Well, I just wanted to say they're not the ultimate authority on what the Idaho law means. That's the Idaho Supreme Court, of course, and it has addressed this issue in the Planned Parenthood case. And I think it's really significant that in Planned Parenthood, the Idaho Supreme Court expressly contrasted this statute with other statutes that contain health-preserving measures and recognized this was a total departure from that. The legislature wanted to focus exclusively and more narrowly on a necessary to prevent death exception. So I think that essentially means that the Supreme Court of Idaho has already touched on this issue, and it's no wonder then that doctors who are facing these kinds of pregnancy complications where in their medical judgment it's not necessary to prevent death yet, but the woman is going to suffer serious health consequences, their hands are tied and they can't provide that care under the Idaho law.
If what's on page 8 and 9 of the reply brief were Idaho law, would there be a problem still?
So if we had an authoritative Idaho Supreme Court decision that said Idaho law allows for termination in the circumstances where EMTALA would require it, yes, of course, then the conflict goes away. But I can't imagine the court would say that because, of course, here. That's
not quite what 8 and 9 say, but I take your point on that. Separate question, different category. I think one of the themes on the other side is that this law passed in 1986 was a very important law addressing a very important problem, namely the problem where hospitals were turning away poor and uninsured patients who came in for emergency care, and the idea was that can't happen. We can't allow hospitals in this country to turn away poor and uninsured people in emergencies. But their theme is that the law was not designed contextually to deal with abortion or other specific kinds of care. And so they make a textual argument, but I think they also make a broader contextual argument about the whole idea of what was going on in 1986. And I want to make sure, I don't think that's really come up too much. I want to make sure you respond to that.
I appreciate having the chance to address that. So at the outset, I don't think they can square that theory with the text of the statute, which says in no uncertain terms, here is the fundamental guarantee. If you have an emergency medical condition and you go to an ER in this country, they have to stabilize you. They have to give you such treatment as may be necessary within reasonable medical probability to ensure that you don't deteriorate. And yes, Congress did not provide a reticulated list of all possible emergency medical conditions and all possible treatments, but it was very clear that Congress set a baseline national standard of care to ensure that no matter where you live in this country, you can't be declined service and the urgent needs of your medical condition addressed. And, you know, it would be no different if the state had come out and decided to ban epinephrine. That's the singular way to treat anaphylaxis, a severe allergic reaction. That would violate the statute, and we would be up here making exactly the same arguments because Congress didn't want that. If you have anaphylaxis and you go to an ER anywhere around this country, they're going to give you epinephrine, and Congress mandated that. And I don't see any way to try to draw lines around to exclude pregnancy complications in the very narrow but tragic circumstances where the only way to address the woman's condition and prevent material deterioration is for the pregnancy to end.
Thank you.